I never thought a physician in America would be targeted because of who they treated. But in their panic to do something about the opioid crisis, the DEA has started targeting physicians in the United States who treat the wrong patients. Those deemed unworthy of effective medical care by some government functionary or algorithm. The DEA doesn't tell you that you can't treat these patients. They just use it against you during indictment and trial. Paraphrasing from one recent trial, we aren't saying you can't treat someone with a criminal record, but you put them at high risk of diversion. When in fact, no diversion at all was proven or even alleged. Attorneys are not prosecuted for helping the accused, even if they know beyond a shadow of a doubt that their client is guilty. It is also assumed that if you don't tell your psychologist or spiritual advisor the truth, at least as you understand it, they cannot be as effective at helping you. For this reason, the clergy are protected from certain laws, as are psychologists. But what about medical doctors? Surely doctors, valued members of society who have dedicated decades of their lives to medical study and the service of others, will be given deference, right? Sadly, no. If a patient admits to a methamphetamine habit but agrees to quit, the doctor can continue opiate treatment according to the Department of Health and Human Services, the only division of the federal government granted the right to voice a medical opinion according to the Supreme Court. But the DEA can still prosecute them for it. How is this possible? Because there is no one powerful enough to make federal law enforcement follow the law. In 1926, the Supreme Court found that direct control of medical practice in the states is beyond the power of the federal government and cannot directly restrict the professional judgment of the physician or interfere with its free exercise in the treatment of disease. This was followed by a Medicare statute, 42 U.S.C. 1395, that expressly ordered the federal government not to interfere with the practice of medicine. These were affirmed by the Supreme Court in Gonzales v. Oregon and again in Ruan v. United States. In Ruan, 2 physicians had been prosecuted for being outside the usual practice of medicine and prescribing without a legitimate medical purpose. The court basically instructed the jury that the doctor's subjective belief that they were acting in good faith didn't matter if the government was able to persuade the jury that the doctor's practice deviated from the norm. What is this norm? It simply does not exist. There is no average patient. After their conviction and on appeal, Dr. Ruan and his colleague ended up in front of the U.S. Supreme Court. Or at least their attorneys did. The doctors were languishing in some gray little concrete cell somewhere. The Supreme Court was told that the usual practice of medicine and legitimate medical purpose was not defined in the law and had to be ascertained essentially from whole cloth during each physician's trial. That the standard of care was not to be found in books or databases, but in the opinions of their paid professional medical witnesses alone. U.S. v. Dr. Bauer. That begs the question of where the good doctors could know what the standard was, but this was the point. There is no objective standard according to the government, and the doctor's absolute good faith efforts meant nothing. This did not fly with the Supreme Justices, who immediately saw the flaw in the government's argument. Without mens rea, a vicious mind, and clear knowledge of wrongdoing, how can a physician be declared criminal? The court ruled that the doctor should not have to prove that their mental state was that of a hypothetical, reasonable doctor. Finding that, for purposes of a criminal conviction under TRA 841, this requires proving that a defendant knew or intended that his or her conduct was unauthorized. So doctors should be safe to practice medicine, right? But they are not. There have been only a few times in U.S. history where the executive branch has refused to follow the judicial branch's interpretation of the law. The first of these was in 1832 with President Andrew Jackson in the case of Worcester v. Georgia. The Cherokee Nation had adapted better than most Native American tribes and had developed a written language, newspapers, and attorneys. When the state of Georgia tried to control lands guaranteed to the Cherokee by treaty, the U.S. Supreme Court found that the states did not have the right to impose regulations on Native American land. But President Jackson declined to enforce this ruling, saying of Chief Justice Marshall, "Now let him enforce it," and refused to protect the rights elucidated by the Supreme Court, allowing the states to control and eventually seize land set aside for the Native Americans, eventually leading to the Trail of Tears. The first Trail of Tears in 1838 had a 27% mortality rate, resulting in the deaths of 4,000 Native peoples on that first death march. The states were so pleased with that result that they did it repeatedly over the next decade and a half, eventually killing more than 15,000 and displacing over 100,000. Today, there is a new Trail of Tears being created by the DEA's refusal to honor the ruling of the U.S. Supreme Court in Rouen. Doctors are being prosecuted for the non-crimes of prescribing dangerous medications in dangerous combinations, which is the very definition of what distinguishes a physician from every other profession, to patients who travel long distances for treatment. Of the 12 listed pill mill descriptors pried from the government's records, none are crimes. In many cases, the government does not try to prove or even allege that the doctor had criminal intent, arguing only that he was willfully blind to the nebulous standard espoused by their medical expert witness, who is paid to advance their opinion and convince the jury. For every physician wrongfully prosecuted, there are thousands of patients thrown out onto the street with nowhere to go. The DEA portends to have numbers to call to help these patients, but these are worse than useless. No physician is going to treat a patient with controlled medications after their previous doctor was sent to prison, and that's exactly how the DEA wants it to be. They will fulfill their mandate to reduce the diversion of opiate medications by simply dictating the practice of medicine by example. Stating clearly through their actions, "We aren't saying that you can't prescribe opiates. We are just saying that we will spend millions of dollars trying to lock you up if you do." This has been extremely effective, with even cancer patients unable to find treatment today. I don't know how many will die in this new Trail of Tears, but I bet it will far exceed what was seen before. Because who can stop them? A united Supreme Court said doctors have the right to treat their patients according to their good faith judgment. Now, let's see them enforce it.